Please, my lord. Lord, I beg to mention item number 22, my lord.
22.
Yes, my lord.
Yes.
I am for the respondent here, my lord. The private
You are
respondent.
the respondent.
Yes, my lord. I may be given some time to file my counter affidavit, my lord.
You want to file counter affidavit?
Yes, my
Because otherwise the matter is an order call.
Yes, my lord.
And who is for the other side?
I'm for the petitioner.
You are for the petition. That's why. So, Mr. Padadilan, counsel appearing on behalf of respondent, please some time. File the counter affidavit around. Is the matter. How many weeks you want?
4 weeks time, my lord.
Okay. The matter listed on the board.
And I further beg to mention item number 28 and 29, my lord.
28 and 29. Is that the MSC appeal?
Yes, my lord. He also, my lord, I have taken the consent of the other side, my lord. Mr. Deka is here.
Mr. Udeka?
Yes. 2 weeks time will be given, my lord.
These are most probably for hearing matters.
Yes, ma'am.
Why you need adjournment? Because it's a matter of 2018.
Yes, my lord. I'm extremely sorry, my lord. I just reached yesterday, my lord. I was out of station, my lord. 2 weeks time, my lord.
Let the matter be listed 2 weeks, after 2 weeks, and the council for both sides is hereby asked to go for the hearing without any adjournment.
Always, ma'am.
In item number 22, interim order is there. Let me be continued.
In 22.
Item number 22.
In item number 22, interim be continued till next date of listing.
Like,
Lord, I am mentioning item number 26. My lord, that may be list after 1 week.
Well, there was
Because-
2 I's actually. What are
Yes,
those I?
actually, yeah, my lord, English Council is out of station due to
So
some
most
person.
probably because other side is not there, so
No,
it is a
no.
case of I think limitation or what?
No, the condemnation of delay condemnation. Yes.
It's going to list after 2 weeks.
After, yes. After that.
Lordship, I beg to mention one criminal appeal pending matter. I am mentioning on behalf of the one Guwahati-based lawyer Barun Singh. In Barun Singh case, Navagantada. This matter will be fixed on 8 day after tomorrow.
Criminal
This is a criminal appeal.
Appeal.
Yes, I record to be heard.
May I please, my lord? My lord, I beg to mention one bail application which is pending in from month of August. So supposed to be listed today, but it is not listed because this matter will be taken up tomorrow, my lord. Thanks. That's all.
May I please your lordship? May I please your lordship?
Yes.
This criminal case arose due to the land dispute case, lordship. This is the then Deputy Commissioner passed an order to hail a mail in the case to settle the dispute. But during the time of hailing a mail, somebody has destroyed the plantation of the respondent, and the mail could not be continued. Thereafter, the FIR was lodged, and accordingly, criminal case was under section 447, 448, 34 IPC was registered. And during trial, lordship, the mail member, those arbitrator, and their name is a arbitrator oblique judge, they submit one report regarding the dispute case, and that was relied by the prosecution as well as the informant. But what happened? The original document is under the custody of Deputy Commissioner. During trial, the accused petitioner has sought an application praying the Honorable Court to direct the Deputy Commissioner to produce this document, because some of the judges has denied their thumb impression, saying that we have not submitted, we have not put any thumb impression in the report, but lower court has denied that application. So I have come this before this honorable court, lordship, and this is the gist of the case, lordship. Now I will take your lordship the impugn order, lordship. Annexure, lordship, 18, page
Is
81, lordship.
81.
81, yes. May I read, lordship? The case is taken up for the hearing IA number 6/23 in RNGR case number 94/9 2019, born out of the Sangram PS case number so and so. Accused Takum, Tokuta Punu, Tokutanam, Tokut Rana, Tokut Thomas, and Toku Rana are present and represented by learned counsel Embar. Seen that the dispense application for so and so. Then V. Tayo, learned APP is present and assisted by counsel for the victim, A. Tama. The instant IA has been filed under the section 91 for CRPC for directing the circle officer Paling Karadari to produce the original document, which is the report dated 28/4/2017, which was been exhibited as the exhibit number 1, signed by 7 arbitrators, middlemen in the mail between the tuner and Taku clan at the helipad ground, Paling. The learned DC has submitted that one of the arbitrator middlemen, Donik Todu, who appeared before this court and deposed as DW12, stated that he had never put any thumb impression on any report, and further perusal of the record reveals that DW12 deposed before this court that instead he put his signature on the document and not merely put his thumb impression, and that thumb impression against his name in the D exhibit number 1 has been forged by someone for miscarriage of justice. Learned DC has further submitted that the deposition of DW against the alleged thumb impression in DW is warranted in the intervention of this court to verify the genuineness of the D exhibit 1. Otherwise, it will be a prejudice to the accused applicant. Learned DC further submitted that the regard DW3 has already lodged a complaint before the police. The Paling police station against the forgery of his thumb impression, so and so. Mr. K. Tama, learned counsel representing the victim with the permission of the court submitted that the issue raised by the DC and IA number so and so is completely different matter than the issue at hand. Learned counsel K. Tama further submitted that the instead case being number so and so on the issue of whether the accused person have committed the offense which has been alleged against them in the case, and the issue of the forgery of the thumb impression is nothing but the delayed tactics of the defense. It is further submitted that the deposition of DW12 in its anomalies regarding the number of arbitrator middlemen who were appointed by the Deputy Commissioner Karadari for the mail between the Tunar clan and on so and so, and further deposed that the order dated on 7/4/2007 passed by the DC Karadari was in fact continuation of the order dated 4/4/2017 and not in superstition. I have heard the respective counsel in details and also perused the IA number. The question before the court is that whether the prayer of the learned counsel for directing the DC Karandadi to produce the document and to send the same for examination by forensic handwriting expert is required for proper adjudication of the GR number so and coming to judicial conclusion. Perusal of the record reveals that the instant trial is for the whether the accused person, namely Tokutakum so and so, and Tokutakam destroyed the plantation of the victim.
Basically, the petition was dismissed, was filed under section 91 of the CRPC.
Yes, Lordship.
So against that order, you have come.
Yes, against the order. And what happened, Lordship? Just annexure page annexure 6, Lordship. Kindly page 33, Lordship. Yes. Page 33, Lordship. This is the report which submitted by the arbitrator or oblique judge, which the Deputy Commissioner has mentioned. And here is the 7 arbitrators who has put their thumb impression. And one of the witnesses said that I have never put thumb impression. Now, what the Deputy Commissioner has last order, that is appointment order, annexure 2, Lordship, kindly see, page 29. there are lordship, 3 appointment order. From page 29, that is 5 names were given. That is Khoda Tabang, Khoda so. Then this was issued on 4th April 2017. Thereafter, mail could not be had. Then next page come to lordship. Another order was issued with the same arbiter. Then on 24 April, lordship. Then the accused petitioner raised objection against this male member, saying that they are having a matrimonial relation with the respondent, so they may not be properly give a judgment. So there must be some neutral body should be appointed. So accordingly, next page, annexure 5 lordship. Annexure 5, 32, page 32 lordship. This is the last order on 27 April. 4 judges were arbitrators were appointed. Now, lordship, they were conducted the bail. But what happened now? Next page, this is the 7 judges is signed, whereas supposed to be signed by the only 4 judges. That's why the accused petitioner have distributed the actual judges, 4 judges, not the 7 judges. And this document is relied by the prosecution. They have exhibited, and court Somoto called all this member as a court witness. That's, this is the logic. So my humble submission, logic, the notice may be issued, and tomorrow it is fixed for final argument because entire evidence is completed, logic, in the lower court, logic. So in interim, logic, till the final disposal of this revision petition, logic may kindly stay the proceeding. That's logic.
Yes.
Lordship, as per this order, Lordship, it is interlocutory order, Lordship. It's not a final. Then tomorrow, this matter fixed for Lordship for final argument. So, Lordship, but this revision petition has been filed with 482, which is the inherent power of the court's Lordship.
Okay.
Lordship, this 480, this 391 Lordship, 401, this petition is filed with 482. With the inherent power of the court, then court may pass any order. But as per my observation, Lordship, this is interlocutory order, and Lordship is not final, and it's come under the revision, Lordship. And tomorrow is the final argument is already been fixed.
So we have raised the matter that under section 91, what application we have filed.
Yes.
So we have filed it very later stage.
Later stage,
Why?
just after completion of this court witness lawsuit. Those who are arbitrators were called by the court as a court witness. After examining, immediately I have filed, not later stage.
Do you think that whether the completion of so and so is there or not, whether he has put all these matters will be heard or discussed by the London court below, because it is a criminal matter, I think 188 to 447, whatever the destruction and all is there. So in that case, whether magistrate will go into that depth, that whether the term impression is his or not or whatever.
Yes. But when the court witness, some of them denied and some of them
Obviously denied.
say, huh? So immediately I have filed, and court has taken time on that. The time was given to the respondent also for hearing. After proper hearing, court has dismissed, rejected my. So there is no option. This is a final order because next step is fixed for final argument in the last order sentence. It is fixed for so there is not a interlocutory order which
No, this
can
is
be
the
reviewed and
interlocutory order, but interlocutory order gives some had any force power of the final disposal. In that case, his petition is mentionable. But we'll see these things subsequently.
So then notice may be issued to the other parties, Lordship, and
Notice definitely notice will
Okay.
be issued. So matter is fixed tomorrow for argument.
yes, final argument. And in June order in the last sentence, logic, it is there. Fixed case on 7/11/2004 final argument. At this stage,
GR
Lordship,
case number 94.
at least notice can be issued and state for timing also if later on found that not.
But subsequently, the offense was explained only on 427/34.
Because
Other sections were not there.
447, then later stage, this learner code below. The previous predecessor has already charged,
Presently, whatever may be, presently the case is under section 427/34 only.
no. And also 447, 427 also. And 34 IPC.
Subsequently, additional charge was paid.
Yes, additional charge came. Then again, the accused, 4 of the accused were not taken statement under provision of 333, 330.
And Mr. M. Hope, the learned counsel for the petition, also heard Ms. M. Hagi, the learned additional PP, appearing on behalf of state respondent. This is an application and section connection with Swenson. Issue notice to all the. So.
And made the informant also in the.
Are you going to appear, you are appearing for
Lordship,
One.
only one.
Only one.
only one?
Yes.
Okay. 2, 3 and 4 are there. So number 2, 3 and 4, no formal notice is required to issue on number 1. As the DPP has already appeared in also. Next step. After hearing the learned counsel, after hearing the submission of the learned counsel for the petition, it is seen that the case is, it is seen that basically the present case is lost against the order dated. What was the order?
Yes, order that is page.
Page 88.
Page 85, Lordship.
82.
Order is of course
Order dated 6/10/2023.
81.
Passed in PRS GR case number 94/2019 in connection with SM GPS case number 88/2017, wherein the order wherein the petition on section 91 CRPC filed by the present petitioners was rejected by the learned court below. It is submitted by the learned counsel, order submitted by the learned counsel for the petition. The case is fixed today for final argument tomorrow, and hence that stays be paid for a stay of the further proceeding of the case so and so. Otherwise, the purpose of filing the present petition will become moot. Considering the submission made by the learned counsel for the present, let the stay go to till the next date of this time, list after 4 weeks.
Yes, offline, Lordship.
Right.
My lordship. Also, this is an appeal against the judgment and sentence order dated 15 September 2023, passed by the learned court below the special judge Pokso, the passer under Leparada district of Arunachal Pradesh. And whereby I have been convicted.
You were on an interim.
My lord. And in terms of that, my lord, I appear before the IO on 15/9/2023, my lord. I place the report, my lord. And again, my lord, on when I appear on 15/9/2023, my lord, I was served with the 41A notice, my lord. Now, according in terms of 41A notice also, my lord, I appear before the IO on 19/9/2023, my lord. 19/9 that I place before your lordship, my lord. So, my lord, yes, my lord,
What is the case for? Cases?
case, my lord.
On the last occasion, CD was called for, and we have received the CD.
You have received.
Yes, ma'am.
No, cases under which section?
Yes, my lord.
447 and 3 of PDPP Act.
3?
PDPP Act.
The maximum punishment prescribed, my lord, here is 5 years, my lord. Now, so my lord, my humble submission would be, my lord, as I am cooperating, my lord, I have been served with a notice under 41A, my lord. At this stage, my lord, I have appeared before the learned oh sorry, I have before I on 2 occasions, my lord. My humble submission, my lord, the interim order, my lord, may be made absolute, my lord. I am cooperating, my lord. I am cooperating with the.
So for the statement, my lord, it is a admitted position that the present applicant accused has encroached in the government quarter land. It is an admitted
Accused.
position,
Accused.
has encroached in the
Objection.
government land, my lord. But however, my lord, after being granted interim by this honorable court, they are complying with the orders.
They also not exactly not encroach, my lord. In the on the record, it is matter of record, my lord, 80 centimeter, my lord. 80 centimeter. I have during the construction of my lord, I have encroached upon my lord. That also I have surrendered. That is matter because I have all my lord, all the thing, my lord.
Heard Mr. Alpha, the learned counsel for the petition, also heard this, which is stating the learned PP for the state of AP. CD receipt, pays the same, hard both same. This is an application in section so and so, in connection with so and so. The learned counsel for the petition for submitted that after obtaining the interim pre-arrest bail on 13/9/2022, he accordingly appeared before the IO and gave a statement in connection with this case. However, subsequently, during the he received another notice, a notice from the IO under section 41 CRPC, and accordingly, after receiving the notice, also he appeared before the IO and helped the IO in further investigation of this case. He is still ready and willing to cooperate the IO in further investigation of this case if he is allowed to remain on the pre-arrest bail. Yes, well, in this context, the learned PP has submitted that it is a fact that submitted that he appeared before the IO and cooperated in the investigation. However, it is a admitted question that there are some enforcement from the side of the petition. But considering the conduct of the accused petitioner, he may be his pair to be considered. Yes, but after hearing the submission made by the learned counsel for the petitioner, also considering the entire circumstances of this case, I find it effective to extend the privilege of the arrest to the present accused petitioner. And accordingly, the order dated 13/9/2023. Accordingly, the order of interim was dated 13/9/2023 is hereby made absolute with same terms and conditions. With the above observation, this stands dismissed.
Next case also, my lord, is the son, my lord. From same affair, my lord, is the son, my lord. Same affair, illegal. Next case.
Same matter for the other person.
Is
Now here you have enclosed 80 centimeter.
80 cent, same for same.
50 centimeter, one is 50 centimeter, one is father and one is son.
One is son.
Oh, watch it. Same order will be there.
Same order.
Otherwise, same.
Same.
Okay, otherwise same.
Hi, lord.
Sir, talk to the government side and make it clear that 80 centimeter, 50 centimeter, what.
My lord,
There is such kind of illegal enforcement of the government property, then definitely.
My lord, on the record, also, my lord, I have surrendered that before the concerned authority, my lord, the deputy commissioner, my lord, that I have also enacted my petition, my lord. Obviously.
Yes.
May I please answer? Lordship, in the last occasion, this honorable court has directed to bring the updated CD, Lordship. Before your Lordship corrects the CD, Lordship, the fact of the case is that, Lordship, there was a student election, Lordship, in the Rajiv Gandhi University, Lordship, for the post of General Secretary. And the applicant, Lordship, he is the student of the said university, Lordship. And they decided to participate in the election for the post of General Secretary. And the complainant supporter, that there is one Tapa Motu, Lordship. He is also contesting for the same post, Lordship. Since the applicant and the accused person, they belong from the same tribe, Lordship. Now, disputed arises between the candidates, Lordship. And after that, during the voting process, Lordship, when the scrutiny was done by the committee, election committee, Lordship, my nomination paper has been rejected, Lordship, on the ground that since I have a back paper in the second semester, Lordship, since I am the third semester student of the mass communication also. On that ground, my nomination paper has been rejected also. In the meantime, Lordship, what happened? The entire supporter of my supporter, Lordship, we have decided to support the candidate who is from the other tribe, Lordship. And during that process, Lordship, there was a verbal argument took place between the complainant and the accused person, Lordship.
Dadagiri was there.
Lordship. In the last, on Lordship, since the out of apprehension, Lordship, we have moved an application on 26/9/2023, Lordship. Now, after that, Lordship, as per the direction given by this Honorable Court, Lordship, we have appeared before the IO, Lordship. And when we went to the police station to give our statement, Lordship, we have been arrested and stayed there for a 1 day, Lordship. We have been arrested by the police on the pretext that since there was another complaint for the same course of action, Lordship, the complainant is different, Lordship. And we have been stayed there for 1 day, Lordship. And after that, we went there in the morning and we were released in the evening, Lordship. A statement has been given already. We are cooperating with the investigation officer, Lordship.
But on the 26/9/2023 direction was also already given.
Lordship, but the
executing a bail bond. So you are on interim, I think.
Lordship. So my humble prayer, Lordship, since we are the student, Lordship, and we are cooperating with the investigation officer, Lordship. Now the interim given by this honorable court, Lordship, that may be made absolute the same terms and conditions.
Yes.
Yes, Your Lordship, I just want to clear certain facts, Your Lordship, as submissions being made, Your Lordship. On the last occasion, the same submission was being made that they were, when they had appeared before the IO, they were arrested in different case, Your Lordship. And Your Lordship at that point of time has clearly stated that not the FIR, the other FIR that he was referring to in this particular case was brought into court's record, Your Lordship. And neither if such detention was illegal, neither any of the complaint was made to the higher authority, Your Lordship. At that point of time, last occasion when the hearing was taken place, Your Lordship, this issue was already dealt with, Your Lordship. The other issue, Your Lordship, will see I have submitted the updated CD, Your Lordship, will see that the injury is grievous, Your Lordship. And the objection being made on the bail is because there were other witnesses, Your Lordship. Since Your Lordship is well aware that this was a student politics on certain, for certain posts in election, Your Lordship. There were other witnesses, Your Lordship. Only some of the witnesses' statement has been taken, Your Lordship. Not everyone's, Your Lordship. That also the photographs of the injury, Your Lordship.
Injury report is there?
Yes, Your Lordship, MLC is there.
Lordship, so far as the Lordship injury is concerned, Lordship, we are also very much concerned for the injury caused by the victim, Lordship, because it was not done by the intensity, Lordship. There was a pushing and pulling between the students, Lordship, and he fell down on the tiles, Lordship. His jaw has been fractured, Lordship. It was not by the using a weapon or something, Lordship.
Yeah. Now, Your Lordship will also see the statement of accused as well as victims, Your Lordship. He was hit by the stone and he has broken tooth, Your Lordship will see. Also, the injury seems to be grievous, Your Lordship. And since he was also a contesting candidate, Your Lordship, and the other witnesses being the student of the college itself, university itself, Your Lordship.
Now, the Lordship, my humble prayer, Lordship, and making a small submission, Lordship. So far as the making a bail of absolute is concerned, Lordship. Interim order has been given by this honorable court, Lordship. We are cooperating with the investigation officer, Lordship. We are not a hardcore criminal, Lordship. We have exam to appear. Our career is on a stake, Lordship. Now, Lordship, I have been informed by the some of the applicant, Lordship, since they are belong from the same tribe, Lordship, the amicable solution could be arrived among them, Lordship. It was not that, Lordship, that they have pre-planned and wanted to cause an injury to the victim, Lordship. It was all happened out of provocation, Lordship. No criminal record against any of the applicant is, Lordship, registered against in any of the police station, Lordship, except this, Lordship.
There was a fracture in the mandible,
Your lordship.
fracture in mandible region.
No,
Lordship.
your lordship will also see that the broken tooths, your lordship will see the pictures, your lordship. That's when the extraction of the tooth happen, and that's where grievous injury.
I humble pray, your lordship, that considering the fact that since they are the student lordship, that the injury caused to the victim lordship, it was an inadvertently out of provocation on the lordship during the election process lordship. There was 1,000 student pushing and pulling lordship.
Yes, your lordship. I leave it to your lordship's discretion only to the fact that one of the submission being made with regard to the illegal detention, your lordship. The other with regard to there is a prospective, he had submitted, your lordship, that they were illegally detained when they appeared before the IO for recording of the statement. That was already dealt with, your lordship, nor an FIR was brought into record.
Legal
Lordship.
detention in the sense you have, when you have appeared before the IO, you were
Lordship.
detained.
We were detained for 6 or 7 hours, lordship.
For
by the
another
police,
case,
lordship.
for
For
another
another,
case.
for the same cause of action, but the complainant is different, lordship. But anyway, lordship, we are not concerning with that fact, since they have been, eventually they have been released by the police, lordship. So after recording all the statement of the accused, lordship, they have been released, lordship. With a strict warning that you should not involve in this kind of matter and all, lordship, they have been released by the police, lordship, after that, after recording of the statement, lordship. In fact, lordship, in this matter, lordship, we are the one who filed an FIR before the filing of the FIR, before the FIR has been filed by the victim, lordship. But we, in a good faith, lordship, we thought that since we are from the same tribe, lordship, we asked the police not to register our FIR, lordship. We are the also one who caused injury during that process, lordship.
Heard Mr. T. Garam, the learned counsel for the petition, also heard J. Jimmy, the learned additional PP, appearing T. Jimmy, learned additional PP, appearing on behalf of state respondent. This is an application, section swears in connection with swears. The learned counsel for the petitioner for this submitted that after obtaining the interim period bill on 26/9/2022, they have already appeared before the IO and gave their statement in connection with this case. Further, it is submitted by that the present petitioner is a student of Rajiv Gandhi,
Lordship.
Rajiv Gandhi University, Rono Hills, Toyama, and he is doing his study in mass communication. It is the fact that further submitted that it is a fact that there was a push and pull between two groups of students during the election process, but there was no any intention to cause any hurt to the victim, to cause hurt to the victims. Though during the push and pull, some of the students got hurt. They have already appeared before the IO, and he is still ready and willing to cooperate the IO in the investigation of this case, if he is granted with the protection of free display. In this context, this TGN, the Randed PP, has submitted that from the medical report as well as from the statement made by the victims, they say that some of the victims sustained grievous injury, and the one of the victim also sustained a mandible injury along with disfiguration of his tooth. So considering the gravity of the offense and the nature of the gravity and nature of the offense, his welfare should not be allowed at this stage. In this context, the learned counsel for the petitioner further submitted that it was the the fight between the two groups of students was not any intentional, and it is on this part of the moment when the they were engaged in push and pull after the result of the after declaration of result in the election, and further submitted that considering his considering the fact that he is a student, he is considering so and so. Most of you were submitted the day before. I also the accused petitioner undertake that he will not do any such kind of offense further, and it was only out of the an incident had happened only during the election of the push and pull between two groups of students. Next, considering this submission made by the learned counsel for both sides, and also considering the fact that the accused petitioner is a student and all other circumstances of his case, I find it a bit to extend the privilege of the respect to the accused petitioner. However,
Lordship, item number 6 to 12 are arising out of same FIR, Your Lordship. Same order may be passed.
11.
these are all students.
Lord, sir, they are all students, Lord, sir.
During this student, this is the college life for the students in this period. If they are indulged with such kind of offenses, then what can you accept?
Exactly, Lord, sir.
Yes. Same order.
Deeply obliged.
Well, all our dates are same. Your interim protection in all dates are same.
Lord, sir, sir.
This is item number 12. Twelve is also same or it's different?
Yes, Lord, sir. 12 we also same, Lord, sir. I'm sorry, Lord, sir, I was in it till 11, Lord, sir. It's till 12, Lord, sir.
That is from 6 to 12.
6 to 12, Lord, sir.
6 to 12%.
Deeply obliged, Lord, sir.
Your Lordship, we have not received the case diary yet, Your Lordship. So matter may be adjourned for further free or further they may be granted
No, my
for
lord.
production of this.
You are on interim.
My lord, no, my lord. I was informed by the learned TV, my lord. He has received the CD, my lord, in the morning, my lord. And he requested me to.
No, if he received the CD, why you will tell he is not receiving the CD?
Your Lordship, I have been told by the PP only the CD has not been received. I don't know why,
Yes.
where my brother gave the instruction, Your Lordship.
Was
From where from you have got this information?
from the PP himself. He was requesting me to matter be listed tomorrow, my lord, for argument, my lord.
No, whatever, you have received the information from Mr. Seri?
Same, my lord. He is in the morning. my
And
lord.
I have been instructed by Mr. Sering only that CD has not been received.
Okay, make it.
My
respond
lord,
to it, otherwise.
if my lord, they are about
No,
three.
he is saying now he is dealing with the case, he is saying that he has not received.
Then my
I
lord,
don't know, maybe this communication.
Then I'll
if
my
it
lord.
was received, the CD was supposed to come, then there may be some reason. I don't know.
If my lord, for education, my lord, is praying for time, my lord, I'll press for interim, my lord. Lord, the applicant, my lord, is a government servant.
Tomorrow.
Tomorrow, my
Can be
lord.
listed.
Tomorrow.
Okay.
You just make it confirm.
Yes, I
whether
will get the
it is received.
confirmation. But
Again,
now
we can-
only
we
he
can-
told me that
Yes,
his
we
CD has
can
not been
get it on
received.
second half also.
Yes.
And if it is not received, that try to get it by tomorrow.
Okay, Your Lordship. Okay. Obviously.
Just he will give us information. Till now, I'm
Fine.
keeping this. Otherwise, we will list it tomorrow.
But please, Your Lordship, in this matter, we have not received the CD, Your Lordship. If Your Lordship, since Your Lordship, though we have sent the order on 12/10/2023, however, since because of the vacation, Your Lordship, Puja vacation, Your Lordship, even the PO could not get in touch with the IOs, Your Lordship. In this case, Your Lordship, if the matter be listed on Monday, Your Lordship, coming Monday.
Otherwise, it is 21C.
Yes, 21C, Your Lordship.
Since when he is in custody?
Since they have been in custody for 66 days. I had filed it on 42 and then including vacation, it's now 66 days, 2 months and 6 days.
So we can fix it on Monday, I think.
Yes.
Let us fix on Monday.
Your Lordship, in this case, without calling for the CD also, I have annexed enough documents, Your Lordship. Illegally, I was arrested since I was having a medical prescription.
Now, this will, we have to CD.
In that case,
because
Your
in a
Lordship,
commercial quantity, I think.
short that may be called for. Scan copy can be called up tomorrow also.
No, Your
What
Lordship,
she says.
not possible, Your Lordship, because we have just resumed the office, Your Lordship. Even the PO has to obtain certain instruction, Your Lordship. Monday, if Monday is the sorted days, I could pray for you.
Your Lordship, I have been in the jail for last 6 days for no fault of mine, Your Lordship.
21C, Your Lordship.
It's a 21C matter, so we have
Yes.
to see, we have to fix it. Because there are certain conditions in 37 also, so we have to see. Monday ki tarikh?
On 13th, Your Lordship.
13th. What? Try to get the CD by.
Yes,
Monday.
yes.
Oblige.
Deeply obliged.
To 19, same. Yes. Oh, same, Nikki. So, what's it? Up to 19, no? Same.
My lord, sorry for interruption. Item number 13, my lord, we have received
What is this, the problem?
just a while ago, my lord.
Huh.
And the CD is very bulky. Can this matter be taken up tomorrow? We have received the CD
Yes.
just a while ago, and the CD is very bulky, so we could not go through the
Okay, tomorrow,
tomorrow, my lord.
13 to tomorrow. Will be. Oh, it's okay. 1 hour, 7. 20.
My Lordship, leading counsel out of station, Lordship. Item number 20.
Leading
J.
counsel,
Genie.
Mr. Who is J. Genie?
J. Genie.
And other side is, you are appearing for the other side?
Yes, my lord. So matter may be listed after Lordship 4 weeks.
4 weeks, he has gone outside for a. Anyway.
For some personal purpose.
Personal purpose. Behalf of the London Council, Mr. J. Gini, the adjournment prayer has been made, where the other side there is no objection. Lady matter will listed accordingly after 4 weeks.
There is a interim, Your Lordship, in item number 20. 21 is also same.
Interim will continue till next date of it. 21 is also same?
21 there is interim may be dropped, Your Lordship.
No. In 20, there is an interim.
Interim, Your Lordship.
But 21, there is no interim.
No, there is a interim, but may not be continue. Interim in 21, item number 21 may not be continued, Lordship.
May not be continued.
Yes.
But 20 would be.
20,
continued.
20.
Why difference?
This is the same analogous matter, but Your Lordship, I've been in
Continue till next date. Then both the
Okay.
matters will continue till next day.
Okay,
Let us see.
yeah.
With a 4 weeks of acceptable, the matter will be listed after 4 weeks. Interim will continue till next day.
Oblige.
But whether there is a continuation of interim. It will be this 20?
Item number 20.
No, this item number 20. Okay. 21 are equally divisible. There's no continuation of order of interim in 21. 21 of continue.
Okay, obliged, Your Lordship.
Yes.
May I please, Your Lordship? On the last occasion, my lord, the matter has been fixed today for final disposal, my lord. In fact, my lord, this matter is a very serious matter, connections to Foxo case, my lord.
Just, Your Lordship, the private respondent seems to be absent today, Your Lordship. They had, on earlier occasion, they had contested the petition, case. There seems to be absent. Miss D. Kamduk.
However, my lord, my respectful submission is level for final disposal.
Yes, for final hearing.
My lord, deeply obliged.
Deeply.
May I please, Your Lordship?
It's 24.
May I please, Your Lordship? This actually what happened, the respondent side, he's I think out of the station, so that's why he has to request me.
Otherwise, you are for the
I am for the appellant.
appellant.
Yes, appellant. And IA is for.
One I is also there, right?
Pardon, Lordship,
I is for,
for condonation of delay, Lordship, yes.
but he already appeared, nah?
Yeah, already appeared. Both two respondent, both are appeared already. And
Understood.
that can be fixed after 2 weeks.
After
2 weeks.
Mr. M. the learned counsel for the appellant. The matter, the I could not be heard due to absence of the learned counsel for the respondent. Let the matter be listed after 2 weeks.
Obliged, Lordship.
Again, number?
Lordship,
Yes.
last time this honorable court has called for the latest update of the case record from the learned court below. So, fact of the case is,
The issue, if I may explain, Your Lordship, why was the LCR, the order dated 8/8/23 was passed, Your Lordship? A charge sheet was filed, Your Lordship, wherein the name of the accused, instead of the name of the accused, different person's name were inadvertently given by the IO, Your Lordship. That was subsequently via corrigendum, Your Lordship, intimated to the learned court below, trial court, Your Lordship. Now, on this court wanted to know if the lower court has taken cognizance of the corrigendum for correction of the name, Your Lordship. The LCR is clear, Your Lordship. The notice has been given to the main accused, who were the actual accused in this case, Your Lordship. The cognizance has been taken with regard to the corrigendum, Your Lordship.
So now he is
Yes.
the person against whom it was wrongly he was charged.
No, Your Lordship. They, in fact, their names were, some another person's name were given in the charge sheet, Your Lordship. Now they have come
we have
while
settled the matter.
agreement settlement, Your Lordship. They have come, Your Lordship. Now, during the settlement, the name reflected in the
Agreement.
accused agreement, the second party were totally different to the people who were charge sheeted in the charge sheet, Your Lordship. So those corrections were subsequently made by a corrigendum, and IA was filed before this court also,
And disposed.
and the IA was disposed of, Your Lordship.
So issue is only that, Your Honor, IO has mistakenly inserted some other person in this case. So these petitioners, they have already settled the case out of the court.
So you are the actual person.
Yes.
Yes. So in
Yeah,
Now,
to understand
whether
this-
there is any correction in the charge sheet also.
Yes, Your Lordship.
everything is
If
done.
I may take Your Lordship to the main petition, Your Lordship, page number
Page
26. it is.
26.
Main petition.
Yes, so this court can understand.
Page number
26 of my petition. See, in the middle of the paragraph.
The
We are-
second paragraph is
Yes.
where the actual accused are, Your Lordship. However, while charge sheeting them in the third paragraph, Your Lordship, the names appear to be totally different, Your Lordship. This was inadvertently done by the IO, Your Lordship.
Now Sri Tana Takum,
Yes,
Yes.
Tana Bullet, Srimoti Takum,
Moni
Monitana,
Tana.
and
that's all.
they are the actual persons.
No, Your Lordship.
They are wrong, they are the.
Wrongly,
Yes,
wrongly.
wrongly implicated by IO in this
Now,
case. Due to
subsequently,
the
Your Lordship
topographical
will
error.
take the IA, dispose of IA, Your Lordship.
So we have filed this subsequently one I number 49.
Item number 49, yes.
Yes, yes.
Page number 13, Your Lordship will see. This is the corrigendum given by the IO, Your Lordship.
I was written here, subject origin, refer case number, Honorable Madam, with reference to the subject cited above, I have the honor to inform you that charge sheet number, charge sheet by New Delhi PS case number 42 of the 22 dated 28/12/22, but inadvertently and by mistake can last paragraph the name of accused Tana Takum, Tana Bolet and Takam Muni Tana
Instead of so and so.
instead of so and so. Because of this investigation officer, Your Honor, this application is pending since the last.
Now, while
two
disposing of
statements.
this IA, Your Lordship, the court on 8/8/2023, Your Lordship, wanted to know if the lower court has taken action with regard to this corrigendum, Your Lordship. Subsequently, Your Lordship will see the last order of the lower court, Your Lordship, the LCR, Your Lordship. It's in the pink file, Your Lordship.
Pink file,
Oh, no, no, it is
in the blue file,
yellow file. Yellow file, है क्या?
yellow file.
Yellow file है क्या? दो है क्या? Pink दो file है क्या?
No, not yellow,
नहीं, नहीं,
blue file,
नहीं, नहीं, pink, pink.
pink file.
Yes.
Okay.
There are two pink files, if I'm not wrong. Two pink files.
No, I want to see the order, whether it's any order, but whether.
Yes, yes, the,
Which file you just.
there are another pink file, I think.
This one.
This one, I think. Dada, Dada.
No.
It's not. Report को देता हूँ. Yes, that file, Your Lordship.
Yes, this one.
Lordship will see summons has been given to the actual accused, who are actually the accused in the charge sheet, Your Lordship.
Case is in a stage of appearance on still.
So going through that order, Your Lordship, the court has taken cognizance of and has accepted the corrigendum given by the
So
IO.
we have settled the matter. This is the case of family misunderstanding. So we have annexed our that settlement copy in Annex 3 of that's a passing petition in page number 47. Also. So we have amicably settled, and now we don't have any grievances because all the parties are belongs to same family members. Only because of misunderstanding, this FIR has been lodged. Moreover, in learned below court stage of case stage is an afference stage.
So, the
Case
case was
number
registered
47.
under section 451, 452,
Yes. 482 is not open.
No, 451, 452, 380, and 34.
Yes.
Case was registered.
Yes. This case was.
Now we have
Subsequent,
settled.
Yes.
subsequently, Your Lordship, it was they were charge sheeted under only 451 and 380.
451 and
380.
We have annexed the charge sheet, Your Honor, in this passing petition. Annexed to page number
Yes,
20.
and regarding portion, do you have anything?
No, Your Lordship, because if Your Lordship will come to page number 19, which is the FIR, Your Lordship.
Hmm, 19 is there. Right?
Yes, these are the FIR, Your Lordship. Subsequently, Your Lordship will see the owner, the complainant was also given the Zimma, which is at page number 45 of the articles which were stolen, Your Lordship.
So articles were recovered from this Jimma of from this petitioner.
Yes, Your Lordship
Yes,
will see at
actually,
page number
yes.
45, which was Caesar memo, Your Lordship.
Yes.
Subsequently, it was handed over to the complainant. While
So
this
now
Zimma.
he has no grievances.
Yes, no
No.
grievances, Your Lordship. I don't have any objection in that case with regard to the
These all petitioners,
Washing of
petitioners,
this.
you know, are same family members. Because of this misunderstanding, FIR has been lodged. That's all.
And This is item number
Item
three. Heard Mr. T. Toku, the learned counsel for the petition, also heard Mr. MS T. Gini, the learned petition PP, appearing on behalf of state respondent. Next one is an application under section so and so, in connection with so and so. For reading. Connection with so and so is 482, huh?
Yes.
CRPC for so and so. The learned counsel for the petition submitted that due to inadvertent mistake of the IO, the case was the name of the accused person mentioned in the charge sheet. Some name of some wrong persons were mentioned in the charge sheet. But subsequently the IO, with filing a corrigendum, named the present accused petitioners as accused persons in the charge sheet history. After an amicable settlement between the parties, they have amicable settlement between the parties. The informant as well as the accused petitioners are not willing to proceed with the case further, and hence, by the instant petition, prayed for the. Now here it is a joint petition.
Yes, joint petition.
And hence, filing this present joint petition, both the informant side as well as the accused petitioners prayed for the quashing of the FIR as well as the charge sheet. The case is pending everywhere.
London Chief Judicial Magistrate Court UP, CGM Court UP.
Charge sheet as well as the criminal case pending before the learned GMFC.
CGM.
Learned CGM UP. Okay, this at a regular DDBA, FIR separate under section. Further submitted that this was the case was filed only due to misunderstanding between the family members, and both the informant and the accused persons belong to the same family, and due to some misunderstanding only, the case has been lost, and which has already settled between them, and they are living peacefully without any differences between them. Further, he submitted that this is a field case to exercise the power under section 482 CRPC for quashing the FIR as well as the charge sheet and the criminal proceeding pending before the learned CGM UP. And there is no probability of any conviction of the accused person, even if the case is allowed to be proceeded. And rather, it will be abuse of the process of the court. Both the parties are living peacefully, and they do not want to proceed with the case, and accordingly, by the instant petition, prayed for the quashing of the so and so. Next, this content, the learned petition PP has submitted that after the corrigendum filed by the IO and the learned court widow have issued the process only against the present petitioner number. Your petitioner number 3. No, your petitioner number.
Petitioner number 49.
No. Your petitioner number 1, 2, 3.
All petitioner. I'm appearing for all the petitioner.
No.
Petitioner 1, 2, 5.
1, 2, 3 are the accused.
Yes. Oh, yes.
Huh?
Petition number, Your Lordship, 2, 2, 5 are the accused.
2, 3.
1 is the complainant.
2, 3, 4, and 5. Now,
yes.
Petitions number 2, 3, 4, and 5. And 2 and 3 and 4. Further, it submitted that the case has already been settled between the parties, and the informant has already received the stolen articles. The prosecution has no objection if the parent petition is allowed by quashing the criminal proceeding as well as the FIR and the charge sheet. So considering the submission with pursuance of Will be found. 20.
Yeah, please, your lordship. Lordship, I'm on behalf of the council that is on behalf of the petitioner, your lordship, M. Biswas.
M.
So,
Biswas.
yes, your lordship. So he's from Guwahati, and because the matter is already listed for orders, all the pleadings has been completed and had prayed that the matter can be fixed for admission hearing, your lordship.
It's not yet admitted.
It is admitted. LCR was called for, your lordship.
For admission hearing, you have seen.
Sorry, your lordship. It was LCR was called for, I think. LCR.
Matter has already been admitted, I think.
Yes, your lordship.
Or no? Do you have any idea?
Perhaps this has not been admitted yet.
Not yet.
Yes, but interim was granted, fixing a date for final for disposal only. But in the meantime, they have filed the affidavit in opposition. They filed the affidavit in opposition on this 30th of last month, your lordship. And now this is for the third time, perhaps this matter is come up before you.
And your lordship, if I may, lordship, in the last order, lordship, they have sought an adjournment. And this honorable court has opined that no further adjournment will be given, lordship. That was because, lordship, when initially then in the stage of motion itself, lordship, they had pressed for the interim. And then it was said that a short date will be given and the matter will be heard and finally disposed of. But on the date when the matter was taken up, they had taken an adjournment. So this honorable court had opined, and it is reflected in order itself, lordship, that no further adjournment will be granted, lordship.
Your lordship will see no further adjournment will be given, but if it is given, the cost can be imposed. That is mentioned in the order, your lordship. And because the conducting counsel, he is from Guwahati, your lordship, he has just prayed. I'm only appearing on his behalf for taking an adjournment, your lordship. So this matter can be adjourned and fixed on 24 days prayed.
But why the matter is on order column? It can be listed for final hearing also. I
It
think.
should
Yes,
have,
your
We have
should have.
received the LCR also.
Yes, lordship.
See, I don't know what is the reason. So why he is absent? He know, I think the date is fixed on 6/11.
Yes, your lordship, but due to some other urgency and I was just informed this morning to take an adjournment, that's why.
Your lordship, at this stage, let it be clarified that whether they would like to file the rejoinder or not, your lordship, because they have filed the affidavit in opposition, the private respondent. So if they don't want to file any rejoinder, then matter may be fixed for the admission hearing. On admission hearing also the matter can be disposed of.
As of now,
I have any clarity.
no, your honor, I was only instructed that the matter can be listed for admission hearing, your lordship.
And my lord, because of this, the interim stay order, the proceeding before the trial court has been kept in abeyance. So that's why we are seeking for an early disposal.
Your lordship, he has prayed for date for 24th of this month itself. So if this matter can be fixed,
This
yes,
month?
yes, your lordship.
So he's coming on 24th.
He is coming on 24th.
Heard MS.
Your lordship.
So and so, appearing on behalf of Mr. Lanet and his counsel, Mr. M. Biswas, and also have Mr. G. Galat, the Lanet counsel for the respondent and the Miss and
G. Galat.
the Lanet petitioner appearing on behalf of the respondent. It is submitted by Mr. Galat that they have already filed the affidavit in opposition for respondent number 2 and paid for disposal of the same as the proceeding in the lower court below is already stayed by order of this court. Further, Mr. T.A.T. Dilane DSLPP also submitted that by the order dated 29/9/2023, it specifically, the order is specifically passed that no further adjournment will be given considering the urgency of the matter. However, the Lanet counsel appearing on behalf of Mr. M. Biswas has submitted due to some urgent personal, due to some urgent reason, the Lanet counsel who is to come from Guwahati not appear before the court and accordingly prayed that and accordingly submitted that the on next day of listing, the Lanet counsel for the petitioner will appear and the matter may be heard on the next date. Considering this submission made by so and so, let the matter be listed for admission hearing on 24th.
Yes, your lordship.
24/11.
Then your lordship, the interim may kindly be continued, your lordship.
Now see, you are on interim, that's why now their submission is just.
I agree
just
that your lordship,
try
but
to go for the argument on 24.
Yes, Your Lordship.
On admission stage itself, it can be disposed of finally also. Interim be continued till next date of listing.
Much obliged.
What will be said? Twenty-seven.
My lord. Here in this case, my lord, this matter, my lord, can be disposed, my lord, and my lord, kindly turn to page number 14 of my petition, my lord.
Page number 40.
14, my lord. What happened in this case, my lord, there was ex parte degree, my lord. Accordingly, this order, page number 14 order was passed in the execution proceeding, my lord. Money execution proceeding, my lord. But I was arrested, my lord.
You are on 40.
14, my lord, 14.
14.
Yes.
41. Okay. 14 means order of this court.
No, my lord, my petition, my application, my lord, my petition.
Main petition. No. One full, na?
My lord.
This is the order.
Order, my lord.
Yes.
My lord, I am reading this, my lord. The judgment debtor, namely such and such is produced by S.I. Nissan, who has arrested a judgment debtor in connection with the present case versus warrant of arrest issue in connection with the present execution proceeding. Had the judgment debtor who is ready to pay an amount of rupees 1000 per month from his salary, my lord. This was my offer, my lord. The digital amount is 5,80,000, which raised in interest including 8,60,000, my lord. Now, as my lord, other side also has reached a consensus, my lord. The respondent, my lord, is also ready, my lord, to take this amount, my lord, 100 or 10,000 per month from my salary, my lord.
So you are the judgment debtor.
Pardon, my
You
lord.
are the judgment debtor.
Yeah, I'm the judgment debtor, my lord.
Rupees 10,000 per month from his salary. So what is the due recovery is 5,80,000.
My lord, interest per annum,
And
which come to an
12%
amount of
per
8,68,000, 8,68,800, my lord. Now, other side also consensus, my lord, if my lord pass a order, my lord, allowing this, my lord, 10,000, my lord, be recovered, my lord, from my salary, my lord, directly deposit to his account, my lord. That can, by this, that way, my lord, this can be closed, my lord.
But the observation of the court was that will take more than 7 years and same is not acceptable.
My lord.
Thereafter, now they are agree. You are agree.
Yeah, now,
My lord. The judgment. So earlier, as per order, as per this order, the prayer was there that 10,000 may be attested from the salary, and it was most probably objected, and the court observation was there that it will take more than 7 years for the recovery. Now you are ready.
10,000.
Now you are ready to accept 10,000.
10,000, my lord, in earlier occasion also we have agreed each other since this now in petitioner has not even paid this rupees 5,80,000, which amounting to 8 lakhs.
Now,
now
as per this order, he was put in the civil prison.
Yes, now
He has been released from there.
yes. So I too agreed, my lord. 10,000 rupees is deducted in my account from his salary. If this court pass such an order, I am ready to accept here, my lord. Otherwise, at all, I am not getting any relief from this total amount. At least I should get something. So I too agree, my lord.
Otherwise, my lord, legally, my lord, this order, my lord, would not be legal, sustainable, my lord. Otherwise, this order, my lord. My lord, no, my lord, there is a certain rule while executing, my lord. Here is a case, my lord. I was brought before the executing court, my lord. There is the executing court is duty bound, my lord, to look into my position, my lord. There is a law is settled, my lord. Person, my lord, cannot be put in jail, my lord, for his poverty, my lord. My situation, my lord, if this case is my long big story, my lord. If my case in that aspect, my lord, if I argue, my lord, it will take long time.
You are still in service?
Yes, I am still in service. That's why, my lord, we have reached a consensus, my lord. Otherwise, my lord, I am a person who is other than salary, my lord, insolent, my lord. For this whole issue, my lord, around is, I would say, my lord, maybe he is getting only 30 or 40,000 only, my lord. Or other order is also there from the court, my lord, deducting my account from my salary. This is the position, my lord. So if he consents, my lord, we can, my lord, by passing that order, the case can be closed, my lord. Otherwise, my lord, if I argue on the case, my lord, this order cannot be sustained, my lord. This is settled by the Supreme Court, my lord. This in the cannot be, my lord. There need to be inquiry, my lord, whether I have a, my lord, only, my lord, not paying is not enough to put this person in prison. There should be a bad intention, my lord, to not to pay, my lord. That is the settled law, my lord. Now, here is a case, my lord, does executing court, my lord, without inquiring to those aspects, my lord, directly put me in the civil imprisonment. That cannot be.
Now we'll pass the order accordingly your the settlement, and we pass the return back the case record to the so and so that the court can pass an order for deducting the salary and so and so.
Yes.
And there will have to be a calculation, interest or whatever. So after the calculating those things, this 10,000 will be deducted from his salary. That order will be passed by the so and so. We'll pass the order now.
Yes. Yes.
So now at present, they did forget about the other things. Now you are agree to have 10,000 per month, which will be attached from his salary.
Yes.
Right?
From his existing salary.
Huh?
From the salary of the petitioner.
Yes, yes.
Yeah. Yes, my lord, we have agreed. So I will furnish the account number. Directly, it should be deposited, and the account number may be reflected in the order sheet, my lord.
In our order.
Just rupees 10,000, my lord, which is going to be deducted from the salary of the petitioner. And same.
You want to supply the account number?
Yes, my lord. I have an account number, so I will furnish it so that order in order sheet that account number may be reflected, so that then only he will comply. Otherwise, this DDO, disbursing officer may not be comply. So it would be best if account number is reflected in the order sheet, which will be passed by this court, my lord.
Mr. Al-Kwame, the learned counsel for the petition. So Mr. G. and Taji, the learned counsel for the respondent. This is a petition under section 115, read article 227 of Indian Constitution against the order dated 23/8/2016 passed by learned Chief Judicial Magistrate UPR in money execution case number 13/2016 in connection with money suit number 30/2015, whereby the learned court below order for civil imprisonment of 1 month against the present petitioner for default of payment of ex parte digital amount of rupees 8,68,800. Next paragraph, it is submitted by the learned counsel for the petition that on being aggrieved and dissatisfied with the order passed by the learned CGM, learned CGM as a Chief Judicial Magistrate in money execution 13/2016, the present petition was filed by the petitioner against the said order. However, during the pendency of this case, there was an amicable settlement between the parties, and presently the respondent is ready to accept rupees 10,000 per month, which may be attached from the salary of the present petitioner. In earlier occasion also, the petitioner was ready to pay an amount of rupees 10,000 per month from his salary, but that was not accepted by the respondent, and the court also passed an order rejecting the prayer for the preparer of the judgment debtor / petitioner, and forwarded the present petitioner for civil imprisonment for 1 month. The petitioner is still ready to pay rupees 10,000 per month from his salary, which may be attached towards the payment of the capital amount. Next paragraph. In this context, Mr. N. Taji, the learned counsel for the respondent, has submitted that the case was decreed. When it was decreed? In 2016.
2016 onwards.
The decree was 2016, but till now they have not received a single penny from the petitioner side, and hence, after considering all these aspects of the case, both the parties have came to an amicable settlement, and presently the respondent is ready to accept this 10,000 per month for towards the satisfaction for its so and so to satisfy the capital amount of rupees 8,68,800. He further submitted that no, accordingly he is up till account number is.
Yes, I have.
He also submitted the account number of the respondent. Respondent, Mr. Niktar Tasang, son of Niktar Tadi, which is in SBI Nirjuli branch, and the account number is 3176-144-8923 with IFSC code number so and so. You give this code number and so and so. And accordingly prayed for to pass proper direction to the learned court below for attesting the salary of the petitioner of rupees 10,000 per month to satisfy the capital above so and so. Next one, after considering the submission made by the learned counsel for the both sides, and without going to the merit of this case, only considering the compromise between the parties, the present petition is hereby disposed of on compromise. Full stop. Let the matter be. We have received the LCR note. Accordingly, the LCR be sent back to the learned court below with the direction to pass necessary order for attachment of salary of the present petitioner. Your petitioner name is
Kumar Ratan, my lord. KUMAR RATN.
Kumar
Ratan RATN.
Petitioner Sri Kumar Ratan. To it is last one. So and so, and to and also pass and also pass the order to deposit the same in the account number provided here by the respondent, Sri Niktar Das. With his observation, the present stance disposed. The IFSC code number is here, you just disposed.
My lord.
Okay, from the next month, can I fix any date?
My lord,
Date will be fixed by the learned code below, I think.
yes,
From each month, that means each month, from the month of, whatever, 1 month you've given.
Aye.
Immediately will pass the order.
Aye.
Then active case.
yes.
And can I fix a date there?
Well, it would be best if the date is being fixed.
Yes.
Otherwise, it will take
And
similar, create
for the-
similar
for the
situation.
Parties are also accordingly directed to appear before the learned code below. Today is,
Today is
sixth.
sixth.
1 week time will sufficient? Where it has to go? The record is. Learned CGM, which,
CGM UPA.
UP only.
Yes, UPA only.
Okay, that's 6. The Diwali is well part over.
That being
Can it
a
be
matter-
14th? 14th?
14.
We'll get another.
Yes.
10, 8, 9 days.
It is only UPA.
Yes, yes.
Yeah.
We'll try to send the recording.
Yes, ma'am.
Send the recording.
Offline.
Okay, so. After a long time, I'm here.
My lord.
Hello.